for those of you who may not be aware of the English system as much, this was what's called a representative action, commenced in May 2017 by Mr. Lloyd. A representative action in English procedure is a claim brought by one or two representatives on the behalf of others who have the same interest, and that's quite an important point for this particular case. And that is to ensure that the representative protects and promotes all of the class's interests as a whole. So this is an opt-out type claim, which means that the members of the class do not have to take any proactive steps, and they do not have to consent to the claim being brought on their behalf. And it also allows for an aggregate award of damages, which is slightly different to what we see in other types of claims, which we'll come on to. So this claim didn't really get anywhere. So the claim was issued in the High Court, and then because it was against a US entity, Mr. Lloyd applied for permission to serve outside the jurisdiction, and this whole claim arose from that one application. And this claim, as I said, was in May 2017 under the old data protection regime, so not the GDPR, but the Data Protection Act 1998 and the old directive. And so Mr. Lloyd alleged that Google had breached its obligations under Section 4.4 of the Data Protection Act, in particular 3 of the 7 data protection principles. And this all related to, I'm sure, what all of you have heard of as the Safari workaround. So this was a double click add cookie that was put onto users' iPhones or activated on users' iPhones when they use Safari to visit websites. And that was done without the user's knowledge or consent. And Mr. Lloyd alleged that that was done with the view to obtaining a commercial gain for Google, because they would then sell that information for advertising. So Mr. Lloyd claimed that he represented every single individual in England and Wales that had the relevant model of iPhone during the relevant period, that had accessed the websites by Safari and had not already altered their privacy settings at their Apple iPhones. He estimated to represent approximately 4.4 million users, claiming a uniform amount of approximately £750 per person, which would have brought the claim value to about £3 billion. He argued primarily that he could seek damages for these individuals on the basis that there had been a loss of control of data, and he had to do no more than that. He did not have to prove there was any damage or there was any distress. In doing this, he relied on what was Section 13 of the Data Protection Act 1998, which said, and I'll read this so I don't get it completely wrong, that an individual who, by reason of contravention by a controller of any requirement of the Act, suffers damage or damage and distress, has the right to obtain compensation. So there has to be, in terms of the Act, a causality effect there. However, he argued that the word damage simply included loss of control. So this went all the way up to the Supreme Court. The High Court, first of all, said, no, you don't have permission. We don't think the claim has, and I'm summarising, obviously, real prospects of success. The Court of Appeal agreed with Mr. Lloyd, and then this went up to the UK Supreme Court. They unanimously held that this claim was not suitable as a representative action because primarily the same interest test was not met. So each individual potential class member would have incurred different damage, if any damage at all, because they would have had different uses of their phone, different internet usage, and so on and so forth. And that all required an individual assessment, which did not fit in with the regime of representative actions. And they found that in order to, trying to get around this need for an individual assessment by boiling the case down to what was referred to as by the Court of Appeal as the lowest common denominator would not work in this particular case, because that would essentially mean any individual who had an iPhone during the relevant period of the right model that had had the cookie put on their phone, and they didn't have to have had the illicit tracking and collection. So that was the main sort of point. And then the other point was that they found that mere infringement of an act does not equal damages. And so in essence, loss of control is not in principle just per se eligible for damages under the Data Protection Act. And they found that you needed to have proof first that Google had unlawfully used the data and that use had caused damage and distress. One thing that the Supreme Court did take quite a lot of pain, or go to a lot of pains to stress, is that this isn't the end, in their view, of representative actions. They consider this, that the test should not be too narrow, and proposed that one option would be that these types of claims could issue on a bifurcated basis, so that the liability is decided under a representative action, and then quantum could be decided either individually or under a group litigation order, which we'll come to. So that's my whistle-stop, very quick summary of Lloyd and Google.
So Ian, as a litigation funder, tell us what was the impact of that decision on collective action and privacy in the UK, in your observation?
Yeah, I mean, well, the short answer to that is that it brought a shuddering halt to not only that claim by Richard Lloyd, but also there were other claims that were filed on precisely the same basis. Those claims in the main were stayed pending the Supreme Court decision in Richard Lloyd's case. And the consequence of the decision by the Supreme Court is that I think in pretty much every single case that was waiting in the wings, they've all now been ended or discontinued. I mean, Richard Lloyd initially brought this claim as a representative action under this specific procedural rule because there is no legislation that permits a class action and an aggregate award in favour of the class to be made for essentially a privacy or data protection claim. So he had to go through this particular route in order to access an award for the benefit of the class as a whole. One reason that funders are now deterred from trying the bifurcated process is that you might be able to get some sort of declaration for the benefit of the class as a whole, but you've still then got to go through the individual person-by-person assessment of the loss that they have suffered in order to get a damages award in respect of each and every individual. And so from a funding point of view, you're not looking at a return based on damages that are calculated by reference to the class. You're now looking at damages that are equivalent to the number of people who happen to come forward to be able to substantiate their claim to loss and are able to demonstrate that they've suffered a loss. And that typically will be a considerably smaller number of people, which means that from a funding point of view, you can't derive the same sort of return that you're interested in relative to the risk that you're taking. So, I mean, we were funding other cases that were parked behind Richard Lloyd's case, and those cases have been discontinued. So it's a pretty much slamming the door shut. Certainly from a funding point of view, there are some clever lawyers out there on the plaintiff side that are looking for ways around, and time will tell whether they're successful or not. Short of that, then the UK government is going to have to step in if there are going to be class actions or collective actions for a class of people for data protection breaches.
So Hayley, I guess that doesn't remove every procedural option for something collective in the UK. So tell us a little bit about group litigation and how that's potentially been an avenue in data protection or not.
Yeah, so I think there's a couple of points. First, there are collective redress mechanisms available in the UK in terms of competition claims. So we do have quite a well-established process. I say well-established, I would say over the last year or so in the Competition Appeal Tribunal. There are also abilities to have cases managed together, so I appreciate they're not group class actions, but that can sometimes actually help facilitate discussions, settlements and the like that we've seen in other cases. But the main other potential way of issuing a group action is a group litigation or via a group litigation order. So these do work, and I'll come to that in a minute, but they are expensive. And so for those of you that don't know what a group litigation order is, it's another specific particular procedural process with which you can bring group actions in England and Wales in particular. And this is whereby each individual claim is issued and a group litigation order application is made. And if that's successful, any eligible claim is then put onto the register. Now this, you'll notice, is already very different to a representative action because it's an opt-in. You have to choose to be involved in the GLO. And so you have to take some time, your lawyers have to take some time preparing your case, submitting it, and then having it added to the register. What this does mean, though, is if your claim is on the register, any judgments within the GLO are binding on you. And one difference, with the representative claims is that your loss can be different because the test for GLO is that there has to be a common issues of fact or law. So, as I say, it's not as high a bar as some might think for GLOs. Typically what happens is there is one or two of the GLO claims on the register are used as test claimants to at least try and try some of the more common issues of fact or law that could be depositive of a claim. And as I say, these do work. We see them a lot in other areas, such as financial reg. There was the RBS rights litigation a while back that was a GLO, but they do cost money up front, and I think that's where the biggest difficulty is. So you need to, as I say, spend some time getting to know the facts of each individual case, preparing the paperwork, getting people added to the register. There's an element of book building here, so you will need to try and encourage people to come to you. One of the biggest issues that's been seen with GLOs is the uncertainty as to the size of the class, because sometimes there is a very low uptake, like there was with the replica football shirts case that Which brought. And then finally, as Ian was saying, funders aren't necessarily as interested in that kind of claim as they would be with, say, something more like a representative action. So, and I can obviously comment on that.
It's simple maths in a way from a funding point of view. If the individual claim in relation to privacy data protection is generally speaking sub £2,000, probably closer to 750, 500. Those are the sort of numbers that are spoken about. You need an awful lot of people to participate on an opt-in basis to get a sufficiently large damages pool that will fund all of the upfront costs, the marketing costs, the book building, the administration of all those individuals, which is why you see group litigation orders for the car cases, the emissions cases, where essentially the damages per person is £25,000. Settlement is generally some fraction of that, but it's still a sufficiently high number that on simple maths it makes it work, because it pays for all of those costs and allows a funder to get a return from that. That's why securities cases that Hayley mentioned as well, where you potentially the claims per individual shareholder are multiple millions. So again, it lends itself to a group litigation order and it works very effectively. In the privacy context, the simple fact of the matter is that the per capita individual figure for loss is too low to justify all of the upfront costs. So you simply don't see these cases. There are a few data breach cases that got off the ground, but
four in total. Yeah,
4 in total.
Yeah, that I'm aware of, that I've looked into. And I think BA has settled. Morrison's was dismissed. There is one that's a GLO application was heard this year that's yet to be decided for the Bennett Equifax, and then there is the EasyJet claim where I don't know the current status on that.
Just one nuance on that. This may be the DeepMind case, I don't know, that's running, but if you can credibly claim that the loss to the individual is much higher because the type of data that is the subject of the misuse is very personal because it's medical data, then conceivably you can get the sorts of numbers that would justify an investment by a litigation funder. But if it's anything short of that, then it's pretty challenging.
I think we're going to come to EU and national laws a little bit later. But let me pop over to Serrin and say, just looking at Lloyd v. Google, is that the kind of fact pattern that we see in the United States? And what kinds of fact patterns attract class actions in the privacy area in the United States?
That fact pattern was actually seen like 20 years before. I mean, some of the early data privacy class actions involved just that fact pattern, one against DoubleClick before it was acquired by Google. But basically, I mean, I think you see anything and everything from the plaintiff's bar in the United States. There's very little cost or risk for plaintiffs to bring these sorts of cases. They have sort of tried and true mechanisms under U.S. law for bringing opt-out classes. You only need to find like one representative plaintiff, and there's no fee shifting. So if you lose, you're not going to be on the hook for defense costs. Plaintiffs, that creates an environment that's very sort of encouraging of experimentation by the plaintiff's bar. I think roughly, like what you see is claims break down into 3 categories. There's claims involving the improper gathering of data. Right now, things like biometric information and claims involving the alleged failure to gather the necessary consent required under certain state laws are a very popular example. I just saw the other day it was a suit against Louis Vuitton for a try-on feature on their website where you can virtually try on sunglasses. And these the plaintiff's attorneys just look for websites that involve any features like that, or any other services that involve any apparent use of facial recognition data. We'll bring a lawsuit. They'll have sort of a template already prepared for a complaint. Another category is unauthorized use of data. So where a company is using data for one purpose after telling users it would only be used for certain other purposes. There's a pending case against Google right now about Google Assistant and how Google is using voice commands gathered from users. The allegation is that they're using it for targeted advertising as opposed to just executing the commands of the user. And then failure to protect data. So, I mean, Hayley mentioned there are 4 data breach lawsuits in the UK. I mean, there have been hundreds and hundreds in the US. Very common for data breach class action lawsuits to be brought in the wake of an incident. And sometimes there are class actions that are brought even without an incident over like a security vulnerability. So with the Spectre meltdown issue involving Intel chips, there was a class action that was brought alleging that like the patch that users had to install slowed down user performance and lowered the value of their devices and machines. So again, lots of creativity that you see.
And one of the paths I think we'll come back to is that there's a very kind of to what you're saying about the legislature needing to act if they want to see this as sort of a private attorney general way of changing behaviors is. In some of these states, they have extremely technical requirements to collect biometric consent. Like the legislature really went to town on what it has to be. So they can find a marginal defect in almost, any, like Louis Vuitton probably thought they had collected some kind of consent, but if you didn't tick and tie, our telephone marketing, consents have similar, things that they have to be very precisely done, or they've had tremendous success because they have these bounties, on the other end. So if they can, make their way through. Ian, tell me, how do funders or litigants or counsel go about finding the kinds of claims they want to pursue? And, feel free to speak to Europe and other places that aren't, DOA, like
well, I mean,
post-Floyd v. Google.
I mean, some context for that question, which is that contrary to where we now are in the UK because of the Lloyd-Google decision, within the EU, all of the states within the EU are now busy implementing a directive that will standardize access to collective redress opt-out claims for damages. And some of the states, there are not many, but some states, the best example of which is probably the Netherlands, already has legislation which permits a body to bring a claim on an opt-out basis seeking damages for the benefit of a class. So your classic class action. Mm-hmm. So that is permitted, so there's no procedural roadblock. So what's happening and what we see at the moment is that all of this activity has been happening in the US, and what we see is that the US plaintiff bar are now setting up shop in the EU. So a lot of the things that are now coming to us as propositions for us to fund are coming through US plaintiff bar, or US counsel on the plaintiff side, who see the opportunity to essentially copycat what it is that they're running in the US, but to now bring that claim within the EU. So that's more and more of a feature. I mean, the other thing that is happening, I think, quite a bit more, which goes to your question, Jennifer, which is, well, where do these cases originate? There's a lot of activists. There's a lot of intermediaries. I mean, the intermediary market has exploded in the last 5 years. So there's a lot of people, former lawyers, people essentially looking to broker relationships between claims that they've read about or seen, funders, law firms. So there's a whole market there of intermediaries.
And they meet in secret rooms.
And
that's how we see it.
Yeah. And so there's no one particular pattern to how these originate. Sometimes it's just much more traditionally that a law firm's been approached by a particular person with a particular claim, and that just comes to us in a very standard sort of plain vanilla way. Other times it comes to us, as I say, through a privacy association who have a particular interest, or it comes to us through an intermediary who wants to put people together to see if something can be done.
So, Serrin, how are these seated in the United States? Like, how do they go about finding a representative or, getting their ideas in the United States if we're the source of all this?
Plaintiffs basically watch the news, and in the wake of any incident, or reported misuse of data, they will pursue that. They may employ their own researchers to look for certain types of privacy issues, like in the Louis Vuitton example. But I mean, I think one thing that's worth mentioning is it's very much influenced by the statutory picture, the landscape in the U.S., which it differs very much from the EU statutory regime, right? So that there's no, as everybody knows, there's no general omnibus privacy statute in the U.S. The statutory law is much less developed, and it varies state by state. And there's only a few privacy statutes out there that have a private right of action, a special right to sue. So class action firms, they rely on sort of long-standing causes of action, general causes of action, like negligence or unfair business practices or privacy-based torts. But those causes of action don't come with any special damages attached. Whereas there are special damages attached to certain types of violations under statute. So there's the Illinois Biometric Information Privacy Act. You get up to $1,000 per violation, sort of basic violation for that statute. There's a statute that applies to just your video rental history that came out of an odd issue from the 80s. Again, there's just sort of a one-off issue that has statutory damages attached. But these sorts of things influence what the plaintiffs bar chase. So you see like a huge number of cases that try to take that video rental history and use it against like, ads or sites that host videos online and that collect information about which videos.
Or just like modern connected TV and digital advertising,
yes.
And say like, okay, I watched an ad and now you're tracking and monetizing that. That's a breach of this ancient videotape rental.
So trying to take anything and shoehorn it into these statutes that allow for statutory damages. So that's how they figure out which subject matters to target. And then in terms of how they find the plaintiffs, I mean, it can be completely random. We had one case where like it was the plaintiff's lawyer's brother-in-law who was the representative plaintiff, which came out of deposition. But otherwise, it's often through online advertising. So in the U.S., you can't directly solicit like in person or over the telephone, but you can advertise to the general public. So plaintiffs' lawyers use like advertising on Facebook or Google, and they'll say things like, "Hey, if you registered an account on X website during 2016 and 2019, you may have a claim for monetary compensation. Please contact us and let us know."